This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Let's have a look at these cases, Sigsworth, Whiteley and Chappell. And it's the stories. I find the stories fascinating. I find them really interesting. And they illustrate the point. This is the illustration of the golden rule, where to follow the literal rule would lead to an absurdity, and therefore they go to court and say, should I really follow the legislation? Do I really have to follow statute? Or surely that's absurd. Sigsworth was the son of farming parents, Mr. and Mrs. Sigsworth, were farmers. And young Sigsworth went to his father and said, Dad, can I borrow £10? I want to go out tonight. I want to go down to the pub. And the father said, no, you go and ask your mother. So he went to his mother and said, Mum, can I borrow £10? And she said, ask your father. He said, well, I already have done. And he said, no. So she said, well, then I'm not going to lend you £10. So he killed them. As you would do, wouldn't you? You'd kill them. So he just killed them. And they had not left a will. They'd not left directions as to how their property was to be distributed when they died. Now that's called dying intestate. You're dying without being a testator. You've not left a will. A person who leaves a will is called a testator. And they died intestate. And there's a piece of legislation called the Intestate Estates Act. And it gives directions as to when people die without leaving a will, who shall inherit the property. And typically it will be the surviving spouse. So if I die, or when I die, my surviving spouse, if she's still around, she will inherit the property. But if I don't have a surviving spouse, then my property will devolve down to my children. But if I don't have any children, then it will devolve upwards to my surviving parents. If I don't have any of them, it goes to my brothers and sisters, and then my aunts and uncles, and then my cousins and nieces and nephews. So there are rules as to how an estate should be distributed. And this guy, having killed his parents, along comes the person to administer the estate, called the administrator. And the administrator says, I've got the estate here, following the rules, the son. He's going to inherit everything. But he's the one who's just killed his parents. Is it right that you should be able to benefit and profit from a criminal act as dreadful as killing your parents? So it went to court, and the administrator said to the judge, do I have to follow the Intestate Estates Act? And the court said, well, the literal rule says, yes, you do, that you must pay the benefit to the person according to the rules. But that's absurd. So we'll apply the golden rule. We will ignore, therefore, the literal rule. And that's one way of avoiding this literal rule, because it's an absurdity. Okay? Whiteley Chappell, this is about a piece of legislation called the Representation of the People's Act. And this says that we all of us in the UK, we all of us have the right to vote in general elections, so long as we're registered as UK residents or UK citizens, and even abroad, even when I'm over here, if there were an election, I still am able to register for my postal vote. So the Representation of the People Act says, people shall be entitled to vote, and people shall not misrepresent themselves as somebody else entitled to vote. So I shan't go along there and say I'm Mike and make my vote, and then maybe later in the day I go along and say I'm Eddie and make his vote as well, because that's against the law. And Whiteley Chappell was a situation where two old men lived next door to each other, and they're very friendly, and they would talk about politics and sport and the news and how the local council was operating not in their interest, talking about their pensions that they were receiving, and did you have a good time in the pub last night? They were really good friends, into each other's houses on a regular basis. And on the day before an election, they were talking, and they decided which way they were each going to vote. And then on the morning of the election, one of them knocks on the door and says, I'm about to go to the polling station, but there was no reply from next door. So he had the key, he opened the door, and there's his friend, dead. What do you do? He said, well, I'm not going to waste my vote. So he went along to the polling station and he cast his vote. And he's sitting at home then, upset because his friend has died. And then he thought, well, I know which way he was going to vote. It's a shame to waste his vote as well. So he went along to the polling station in the late afternoon and said that he was the name of his dead friend, and he voted on behalf of his dead friend. Has he committed a crime? Has he committed a crime? No. Yeah, by voting twice, but he knew which way his friend was going to vote, and therefore it's not really a crime, is it? Yeah? And not according to the Representation of the People's Act. It is a crime to misrepresent yourself as somebody else entitled to vote. Well, he didn't. He misrepresented himself as a dead person, and dead people don't vote. So in fact, technically, he was not breaking the criminal law. He was not misrepresenting himself as Eddie, who was alive and able to vote. He was misrepresenting himself as someone not entitled to vote, and therefore should not be found guilty. And the court said, this is absurd. This is against completely the spirit of the law. It's an absurdity. We're going to ignore the literal rule, and we're going to find this man guilty. And prison, if you misrepresent yourself as someone else, you finish up in prison. Poor old man. Mischief rule. The next one. Mischief rule. What is the statute trying to control? Statutes don't come out of nothing. Statutes don't suddenly appear. Statutes are because 10 members of Parliament have been asked by their own constituents to think about introducing an idea to the Houses of Parliament, and the Houses of Parliament then will say, well, why do we need it? Sometimes it's innovative. Sometimes it's because there is no law on a changing society with reference to the changing society. So that would be innovative legislation, innovative statute. It's new. It's completely never been thought of before, never been needed before. The example I would tend to use there would be in the area of surrogate mothers, where a woman can not herself carry a child, but nevertheless she can provide an egg, and the male can provide the sperm, and this will be then grown in another woman, and the other woman will carry the child and deliver it, and then you pay this other woman for carrying your child for 9 months. This surrogate motherhood activity is new. It was never around when I was your age. It was never even thought of when I was your age. So we need new legislation on it because it's an area that has never previously been thought about. When motor cars, you didn't have a Road Traffic Act in 1850. There was no Road Traffic Act that says you cannot drive your horse at a speed greater than 70 miles an hour. It wasn't applicable. So things change, and as the society changes and technology changes, we need innovative legislation. How have I got there? Oh, other legislation often, it's not always, other type of legislation, if it's not innovative, will be consolidating legislation, which will take all the different pieces of bits of legislation in a particular area and add them all together and just have one combined piece of legislation, one combined act. And the example of that will be the Companies Act 2005. The Companies Act 2005, where all the bits and pieces of insolvency legislation and company regulation legislation, all of this is added together and is now combined to make the Companies Act 2005. Codifying is the one that I'm talking about at the moment, codifying legislation. To codify, to put into statute form the law which has developed not in statute form. So there's a lot of common law developed over a period of many years, over hundreds of years, the law which is now commonly applied throughout the country, but it's not written down. It's just developed and is based on precedent and based on established principles. But every now and then the Parliament will get together all the common law in a particular area and they will codify it and put it into statute form. So this non-written common law, developed over many centuries, can be then codified. And one of the elements of codification is that it was necessary to create the law. Why was it necessary to create the law? To protect the people who were involved. This particular case here, we've got two cases actually, Gardner Sevenoaks and Gorris and Scott. This was an illustration of the mischief rule. What was wrong with the existing situation that required us to pass an act, to pass legislation to govern what was wrong with the existing situation? So we're looking at the mischief, looking at the existing defects of the law as it exists, which then caused the new law to be written. And that's what judges will do. They will look at the defects which did exist in order to determine the meaning of the later statute. And that's what we have with these Gorris and Scott and Gardner Sevenoaks. Gardner Sevenoaks Sevenoaks is a town in southeast England. It's actually Sevenoaks District Council or Town Council. And there's a piece of legislation called the Cinematographs Act. The Cinematographs Act. And within the Cinematographs Act, there is the expression that says that film shall be stored in premises secure from fire. That film, if you're going to store film, then you must store it in premises which are fire resistant or not likely to, secure from fire. And if there is a fire, it will be put out by the sprinkler system or by the exploding gas walls with the inert gas which will kill the fire. So the Cinematographs Act has this requirement that says film shall be stored in premises secure from fire. And Gardner wasn't. He was storing his film in a cave which was on his land. So he's got this cave. I don't know why he wants to store film, but he does. He put the film in the cave, and the local council discovered what he was doing and said, "You're in breach of the Cinematographs Act. You're not storing your film in premises secure from fire." Because a premise is a house or an office or a factory or it's an edifice, it's a building, and a cave is not a building. So he defended it and went to court. And the court said, well, what's the mischief? Why does the Cinematographs Act require storage in premises secure from fire? And the answer is to reduce the fire hazard. Okay, well, if that's the mischief, how hazardous is a cave? Do caves suddenly burst into flame? Or if there is a fire and the film is destroyed, is the fire likely to spread around and cause danger to other buildings in the area? Surely the mischief was the prevention of the fire hazard. Surely it must be safer to keep your film in a cave than in a building. So the court found him not liable, not guilty, because although a cave is not a premise, the importance of the expression was not, it shall be stored in premises secure from fire. Surely the emphasis was, it should be stored somewhere secure from fire. That's the emphasis. That was the mischief. So the court will look at the mischief rule to interpret the meaning of the words within the statute. The other case we have here is the case Gorris and Scott. Scott is an English first name. It's a Christian name in the UK. So this will be on your Christian name list. I think there might be a film list. How did I do a film list? Cars, forenames. Gorris and Scott you'll find on page 129. It actually says Garrod and Scott on page 129. It should be Gorris. So I've got the name wrong in page 129. Gorris it should be. And there is a films list. Gardner and Sevenoaks is on page 134. Gardner and Sevenoaks is on 134. And Gorris and Scott is on 129. Tell me again? The Golden Rule? No, there's only the two cases I've given you. There's only Sigsworth and Whiteley.
Whiteley and Chappell I could find here, but this one I couldn't.
You can find Sigsworth. No, it doesn't fit into any list. They're not all the cases are listed out, just those which coincidentally happen to have a common feature which is nothing to do with the law. Okay, so just because Sigsworth is in the notes but it's not in the case lists doesn't mean to say it's any less important. It's just that, do you realistically expect to remember all these case names? No? Well, if I miss some out, then it's not a big deal. And you can remember, just imagine, close your eyes for a moment, or just close your eyes. Now then, you've just gone to your dad and said, Dad, can I borrow some money? He said, no. You go to your mum, can I borrow some money? Mum, no. So you reach for the kitchen knife and you kill them. That's all you have to do is imagine that, and you can remember. Yeah? The law for Sevenoaks, the application of the mischief rule. Statutory interpretation, mischief rule. But I'm leaving that to you to determine the area of law. Okay, in your own words, you can identify the area of law, and that would help. If you think of it, then it will help you remember it. Okay, Gorris and Scott, I didn't tell you the detail. This is about a piece of legislation dealing with the transportation of animals on ships. So it should actually be in your ship list as well. No, it's not in your ship list. It should be. Gorris and Scott should be on page 126 as well. It's about the carriage of animals, live animals, on ships. And there is a piece of legislation, I don't know what it's called, piece of legislation that says that animals should be carried in pens, in enclosures, on the deck of the ship. So we've got the ship there, and on the deck there should be these enclosures to carry 10 or 12 pigs, sheep. This particular one, it was sheep. And they should be separated like that and should be kept in these pens. And the idea of keeping them like this is that if some sheep in this bottom pen here, if some sheep fall ill and have a contagious disease, then it doesn't mean that the sheep is running around the entire ship spreading the disease to all the other sheep. It means that it's restricted to just 10 or 12 others, and the remainder in the other pens, hopefully, will not be affected. In the case Gorris and Scott, there were no enclosures. These were not on the deck of the ship. So the sheep were running around. The sheep on the ship, running around, and a big wave came. Phew! Sheep no longer on ship. Swimming sheep. And sheep are not known for their swimming ability. So these sheep drowned, and the ship landed at port, and the farmer came down and said, "Where are my sheep?" And he said, "They're swimming about 800 miles out there. They'll be along soon." So he sued. They sued the ship owner on the basis that the ship owner had failed to protect the sheep by putting them in enclosures, and therefore the ship owner should compensate the sheep owner. And the court looked at the mischief. They admitted, they said, we didn't have any pens, but the court looked at the mischief and said, what was the fundamental reason behind the requirement to have these enclosures? And the fundamental reason was to prevent the spread of disease. It wasn't, just in case a big wave comes along, at least the sheep will hit the fence before they fall overboard, because they would have fallen overboard anyway. The big wave would have swept the pens as well. So the mischief was the fact that we wanted to prevent the spread of disease. And by applying the mischief rule, the fact that we hadn't built the enclosures became irrelevant. So the interpretation of the statute was that the statute was there to prevent the spread of disease. not to prevent sheep from being swept overboard. Then we get another bit of Latin, eius dem generis. Eius dem generis. And it means things of the same class. Things of the same class. Things which are realistically similar, that you can put them into a class of items. So if I start talking about diamonds, rubies, emeralds and others, then I can only put into the and others things of the same class as the diamonds, rubies and emeralds. So the rule goes like this, that where in a statute we have specific words followed by general words, you can only include within the general things which are of the same class as the specifics. So diamonds, rubies, emeralds are all precious stones. So included within and others would be sapphires. But it wouldn't include garnet or zirconium or semi-precious stones, therefore. So if I specify and then generalize, I can only put in the general items which are similar to the specifics. If your apartment rental contract says that you shall not keep cats, dogs and other animals within your apartment, does that mean you can keep fish? Well, I suppose technically fish are not animals, are they? Does it mean you can keep a rabbit in your apartment? Well, no, it doesn't, because rabbits are domesticated. It depends what you're keeping the rabbit for. If you're keeping it for Saturday lunch, then you probably can. But can you keep a horse in your apartment? You took it in when it was only a little horse. Now it's a big horse. You can't get it out. So there you are. You've got this horse sitting in your apartment. So cats, dogs and others. Well, actually, your apartment rental contract says, yes, you can keep a horse, because a horse is not a normal domesticated pet that you would expect to find in an apartment. Try it. Try taking a horse into your apartment. See what your landlord says. So cats, dogs and others limits the others to the interpretation of domesticated pets, whereas a horse is not a domesticated elephant. Take an elephant up there. See what your landlord says then. We have the case Evans and Cross, and this is about road traffic incident. And we've got a crossroads, a junction, and there is here, that's the white line down the centre of the road, there is here a sign on the road that says halt. It's on the correct side of the road, you'll notice as well. It says halt. So you've got to stop and wait for traffic on the main road to go backwards and forwards, and then you can cross. And a man didn't. He came along here, he didn't stop, he went straight over, and there was a police car there, and saw that he had not stopped and he had gone straight over. So the police car followed him, stopped him, and prosecuted him and said, you are in breach of the Road Traffic Act. The Road Traffic Act says that you shall obey all direction posts, finger posts, signposts, and others. Direction post is a post which points you in the direction. A finger post is in the shape of a hand with a finger, and it points you in a certain direction. A signpost is a big sign which tells you which direction you need to go to get to wherever you want to go, and others. He defended it and said, I'm not guilty. I have not disobeyed the Road Traffic Act. Eius dem generis. This is a word written on the road. A direction post, a finger post, a signpost, These are all things above ground. These are not things which are written on the road, and therefore I've not broken anything. Others does not include words written on the road. And he was found not guilty. He did not break the Road Traffic Act. The Road Traffic Act, when you interpret the Road Traffic Act, you do so eos dem generis. Signposts, finger posts, direction posts, and others. And the others do not include words written on the floor. Oh, be quiet. I don't know why the judge didn't apply it. Probably because it's not so absurd. It should have been more carefully worded. I don't know. Another little bit of Latin. Expressio. Now, some Latin, because English has got a lot of root in Latin, you can actually translate some Latin just by looking at it and knowing similar English words. And I'm suggesting to you that you could work out what that means. What do you think the first word means? The first word, not the last word. Arthurs. Well, put an N on the end of it and then tell me what you think. Go on, put an N on the end. Expression, yes. It means expression. Unius. One. Manchester United. Manchester Unius. Manchester. Unius. Expression of one. Est. Est is in every language and it always means the same and it doesn't mean east. What does est mean, do you think? Yeah. Is. Yeah, expression of one thing is. Now then, Eddie. Exclusio. Exclusion. Well, therefore, you have to be able to guess ulteriors. Others, the alternatives. The expression of one is the exclusion of the others. Yeah. The expression of one is the exclusion of the others. If a piece of legislation specifically identifies rubies and diamonds, but it doesn't use the general expression and others after it, you shall not smuggle rubies and diamonds out of the country, then it does mean that you can smuggle anything else out. The law is restricting its application to just rubies and diamonds. So the expression of one, by specifying one or two or a group, then you are not putting the general words and others, then you are allowed to do whatever you want with the others. You can smuggle sapphires, you can smuggle garnets, zirconium, you can anything, so long as you don't smuggle emeralds, rubies and diamonds. The expression of one is the exclusion of others. Noscitur socies. I don't think you'll be able to guess that. Noscitur socies. I'm sorry. Well, I don't see why I should apologize for the use of Latin within your English law syllabus. So noscitur socies says the meaning of a word can be derived from its context. The meaning can be understood from the context that it is in. I gave you the example earlier of one word meaning diametrically opposite things. Contain means two completely opposite, to hold within or to hold without. In a very famous classic poem, Horatio and his two friends stood on the edge of a narrow bridge while all the other bridges from the city had been destroyed, and 10,000 enemy came to fight and invade the city. And Horatio and his two friends stood on the edge of the bridge, and these 10,000 were coming at them, and they contained the enemy. They held them back while the other citizens destroyed the bridge behind them. And then when the bridge had been destroyed behind them, these three then dived into the water and swam across, and 10,000 frustrated soldiers are waiting to invade. So Horatio contained the enemy. Does that mean he's got the enemy inside him? Is that what it means? No. Whereas a bottle containing water clearly is not holding the water out, it's holding the water in. So the meaning can be derived from its context, its social neighbours. That's where the Sockies comes in. The meaning can be derived from its social neighbours. You may refer to it as the contextual rule. Then we got another little bit of Latin in Pari Materia. This has nothing to do with the French capital. In Pari Materia means sometimes legislation is passed as a series of acts. So I'm thinking back in 1873, 1875, there was a series of acts called the Judicature Acts of 1873 to 75. Now, if you're going to interpret a word within the 1873 Judicature Act, that 1873 Act is part of a series, the 1873, 74, 75. So if I've interpreted a word in the 1873 Act in one particular way, then I must be consistent and interpret that same word in the later two acts in the same way. So in Pari Materia, pari means equal. In pari means equal. So we have three pieces of legislation, but they're of equal status and they are effectively one piece of legislation. So in Pari Materia, if I interpret it once, then I must be consistent. The purposive approach, this is why I suppose it's called a common sense approach, really. The purposive approach, as society changes over a period of time, society begins to accept, depends where you are in society, but society begins to accept changing social values and changing social standards. When I was a child, it was absolutely unheard of that a man and a woman should live together if they weren't married. Oh, the scandal in the village. If a man and woman were living together and not married, this was and a child born into that relationship, oh, the poor child, growing up with the stigma associated with unmarried parents. And now, I'm not going to ask, but now I think you'll accept that it's a common factor, isn't it? It's probably no less common than husband and wife living together. So, as things change, then the law must also change. The law must interpret differently. So man and wife living together but not married, when the man dies, where does his estate go? Well, surely it ought to go to the woman with whom he's been living as though they were man and wife. It's called a common law wife in the UK. But legislation has only started acknowledging these partnerships out of marriage. But it's also started acknowledging that if a man and woman can live together and not be married, why then can a man and Eddie and me, why can we not live together? As though we were in a close relationship. And why can two women not live together? What's the problem with this? It may be offensive in some parts of the world, I've no doubt it is. And there are bits and pieces in little areas within Europe who also find it difficult to accept same-sex relationships. But the purpose of it in the UK, remember, English law, English judges and English courts are acknowledging the realistic nature of a relationship of two people living together. So the purposive approach, the courts are prepared to accept what are called civil partnerships. That's a partnership of two people of the same sex. So the purposive approach. And European law demands that local legislation recognizes. There are parts of Europe who refuse to accept this and therefore are in direct conflict with European law and won't allow the gay pride march to march through their main cities, their main centres. It won't allow them to do it. But at the same time, they allow the neo-fascists to walk through their main street. There are parts of Eastern Europe, not far from here, who allow neo-fascist marches but don't allow gay pride marches. That's wrong. But we're not doing Baltic law, we're doing English law. And English law says yes, you can. You can even be a neo-fascist gay and go on both marches if you want. I think that's probably a contradiction. I don't think neo-fascism would accept gayness. But anyway, we cannot interpret statute which would lead to conflict with European law. It's only going to be a matter of time before we call ourselves the United States of Europe. It's only a matter of time now. The European community, the European Union, eventually we're going to accept that the United States of the former Soviet republics, the United States of America, it's only a few years, I would imagine, before we call ourselves the United States of Europe. A common currency, common language. Can you give up? Do you see yourself giving up your language? No way, absolutely. So the common language is therefore going to be, shall we say, Estonian. And everybody's going to learn Estonian, or Latvian, or Lithuanian, or Romanian, or Urdu, or what. So, no, we will be the United States of Europe. And therefore, it is accepting now that if we're going to have a European Union, a European community, then we should have consistent application of law. So we can't pass, and you can't pass in your country, you cannot pass legislation which is in conflict with Europe, because we're trying to harmonise, trying to make it consistent.